Good afternoon, Council Piri. Just want to find out whether you are getting us. And there's 4 minutes gone already after 14. We perhaps give it a few minutes before we start as we wait for our colleagues to log in. I want us to finish up on the business that we started last week. We did deal quite exclusively with what is meant by consideration. And we saw that consideration does play a very important role in terms of appreciating its position in contract for the bearances of losses and gains, and well defined in the celebrated case of Dunlop Pneumatic Tire Company. This is Selfridge. Right, maybe as we wait for our colleagues, just maybe trying to run through the general working principles, and perhaps we will find us as they come and as they join along. And so you are seeing very well that we have quite exclusively dealt with various aspects of contract, and perhaps starting with the classic fear of freedom of contract. And we saw that an important aspect of movement from status to contract, which was perhaps bringing one key important aspect, and we saw that it did really bring in an act of appreciating the fact that not only were we going to deal with the meeting of the minds, but perhaps espousing the objective test that now has come to play. And the objective test itself, which was exemplified in the Oxford, rather the Salford University College case, is expressive of what we are looking at. I think more so maybe to put it in proper perspective is the case of Moran versus the University College Salford number 2 case, which does give a highlight of touching on the objective approach, which was perhaps illustrated so well in the celebrated case of Moran versus the University College Salford number 2 case. And we went on further to look at the classification of contracts, and I think that was quite key and very important. And distinctively, and we saw that traditionally the classification of contracts is perhaps divided in 2 deeds and simple contracts, of which we did look at the deed, and we saw that a deed is of ancient origin and does derive its validity from the form in which it could have been made. And I'm sure as we've been traversing around with the various working principles, you've seen how this important information has assisted us in really coming up with a proper understanding of the various classifications of contracts. Other than that, perhaps deeds, they can then be classified in terms of simple contracts, which could manifest in terms of bilateral contracts or unilateral contracts. And you saw that for bilateral contracts, perhaps it would involve a promise by one party, which could be exchanged for a promise by the other. And that was quite exclusive and quite intriguing. And of course, it went without saying that when we went to the second limb that would have been referring to unilateral contracts, and one party would promise to do something in return for an act of the other, okay? And that perhaps could have been opposed to a promise. And I think that was quite interesting, because then I think it was really preparing us to know and how we would handle perhaps the different types of challenges that would manifest in terms of the kind of problems that would manifest in terms of contract law. As you know that contract law sometimes does literally become mind-boggling, because then it would call for you to really know and maybe appreciate much more where the specific important key aspect would come in, right? So the elements of a contract were then espoused further, and so it was quite really interesting to perhaps see how we would be dealing with aspects to do with an agreement, where there's offer and acceptance, and so having to have legal intentions and so on and so forth, consideration, issues to do with capacity and so on and so forth. Now, these things are very, very key and are very, very important. Okay, now I've been talking about these things and been trying to perhaps buy time as we were waiting. Council Nompumelelo, good afternoon. I hope you are okay. We were waiting just for colleagues that I was just saying, no, let me just perhaps have just a general, talk surrounding what we have so far looked at. Where are our colleagues, Leonard Council?
Good afternoon. I don't know where the others are.
I'm sorry, Leonard Council, I didn't get what you were saying, so you were a little bit low.
I was saying good afternoon. I don't know where the
Good.
others are.
Okay, right. Okay, so yes, but it was communicated to them. It was communicated to them that we were supposed to have at class, isn't it? Yes, Councillor.
I presume they know that they're supposed to have class with 2 Wednesday, but they didn't
Okay.
ask them in the group.
Okay, no, that's okay. They will find us. They will find us because, in fact, I'm very busy looking already at the assignments we and before Friday you have a feedback on the assignments. I'm actually busy looking into them, and maybe the reason why they could have taken time is the fact that we needed to have perhaps handled them carefully, right? Okay, so that was really just a word in passing, and of course, as I must have said that we did spend quite a considerable amount of time. That was as of last week to look at consideration. And I thought today it's very important that we look at another important component, which does refer to privity of contract. What is privity of contract, right? And so, how does it then assist in dealing with contract law? Now, you do remember very well that where we were coming from, we had a very interesting case which did perhaps take center stage in terms of tort law, and that was the celebrated case of Donoghue versus Stevenson, 1932, appeal case 562. Now, this particular case does bring some very interesting jurisprudence, and you may have noted from that particular case that a very important component of law was brought out, and that was perhaps privity of contract. And we saw from what it transpired in that particular case that the courts did pronounce themselves so well. We had an opportunity perhaps to have dealt with privity of contract because it was well spelled out and well answered through the celebrated case of Donoghue versus Stevenson, where Lord Etkin perhaps brings in the neighbor principle. Who is your neighbor at law? And we did see very well that their lordships went an extra mile to labor in defining what privity of contract was and the effect though that it would have in terms of contractual obligation, right? Okay, so what is privity of contract? So this particular rule of privity coming this particular rule of privity does exemplify one important thing. It means that in general, a person who is not privy to a contract that is a third party can neither sue nor be sued on that contract. Okay, Council, you are welcome. Except you are late today. What happened? Sorry. Oh, I see. Okay, but you are welcome. And I was just telling your colleagues that we just introducing another important topic, which is privity of contract. And I hope you've been following. I hope you, and I pray that you followed the presentation and perhaps the lesson on consideration in our last meeting. Okay, so the rule of privity means that in general, a person who is not privy to a contract, that is a third party, can neither sue nor be sued on that contract. So if you're not privy to a contract, then perhaps you cannot sue, rather. But then you see that there's a certain way the law does look at these particular important aspects, and it's really in terms of trying to look at the various exceptions that really do come across that have assisted us. And of particular note is that the common law doctrine of privity of contract does state that a person cannot be bound by or perhaps take advantage of a contract to which he is not a party, right? And so the doctrine which had been developed by the common law judges, perhaps by the mid of the 19th century, was reaffirmed by the House of Lords in the celebrated case. And perhaps this came in terms of now highlighting the major elements that you must have noted and seen in Dunlop Pneumatic Tire Company. This is in Selfridge. So the rule of privity means that that in general, a person who is not privy or privy to a contract that is a third party can neither sue nor be sued on that particular contract. And the key case which we will set the ball rolling is the celebrated case of Dunlop Pneumatic Tire Company versus Selfridge. Now, from this diagrammatic representation that perhaps you are seeing in the council, maybe you can just capture this and send it into the group so that the rest of our colleagues can really see what we are looking at. And what you are seeing here is that Dunlop does sell to Dew. Dew subsequently sells to Selfridge, who are in this particular case the defendants. And expressively, the action fails because one was not privy to the contract. And so in the geometrics of what you are seeing here, we are trying to build context. And again, on my other side of perhaps my far left here, what you see in terms of being exemplified is other than that particular key celebrated case that I have cited, just from this is Horizon Holiday Limited, 1975, and again, a case that is quite expressive of these things that we are talking about. That in itself does exemplify what we are referring to, but then I've labored a little bit better to break it down. So I do make it quite easy for you to know as to how these important aspects are looked at. Okay, so, and again, of particular note here, colleagues, is perhaps to note that although privity of contract has been regarded as a fundamental principle of English law, there is a large number of exceptions to the rule. And these particular exceptions that I am interested in, that I wish to perhaps bring to the fore, that you have to know them. What's your surname again? Gaspar? Oh, that's like Council Magondo, right? All right. So yes, Council Magondo. Yes, it's the respective, exceptions that then make us appreciate and know what privity of contract is. And these particular exceptions range from assignments of contractual rights. So you can take note of the following exceptions that we will spend some time on. And the first one is one that talks about assignments of contractual rights, Council Nompumelelo, right? So you take note of the first aspect of that, which has to do with assignments of contractual rights, and the second one, which apparently does deal with agency. And so agency for us is big business. And again, I'm going to explain how that Council Nicolette is perhaps put into proper perspective, right? It will be put into proper perspective. All right. And again, before you came in, we had a chat with, was it Council? I think in passing, I must have been saying that the reason as to why perhaps you didn't see a feedback on the assignments because we were trying to give the kind of best treatment that they needed, and you will be getting feedback on them. But suffice to mention that colleagues, let's write using the proper, perhaps laid down format for writing assignments. You are now at this particular level. It's presumed perhaps that you would have understood your legal writing skills well. And so, Council Casper, I'm looking at your assignment and I can't see the footnotes, right? I'm looking at your assignment. I'm looking at Council Mpumelel's assignment. I'm looking at Council Nicolette's assignments. But I can tell, Council Paul, I'm looking at your assignments. And specifically, I can pinpoint, I can even tell you what, that you did not cite. And you know that citation is very, very important. You don't use in-text citation, but you use footnotes. Yes, right. So you've seen that we take these things very, very serious, right? Yeah, so we are on them, and basically that is literally the case. So other than agency, you can equally also cite land law. How has perhaps privity of contract, played a role in terms of dealing with land transactions? And again, if you remember very well, what I was saying is it's what we are discussing here in the contract that we'll have perhaps to deal with in other aspects of real life practical terms, in terms of the contract, right? That the contract is understood from a general perspective, but you find itself in the other aspects of real life practical terms, such as in your conveyancing, and perhaps in the different types of agreements. It could be perhaps in agreements that have to do with the landlord and the tenant, and so on and so forth, and so other areas of agreements which perhaps could even also be there. So when it comes to land law and development, we will note that privity of contractors also had its own bearing. And other than in land law, there is also an aspect that has to do with trusts. And again, at this particular juncture, colleagues, because now you've been exposed to the law, you understand that a trust, I think more especially in these modern days, that, and I'm sure you perhaps maybe already people have been approaching, isn't it, Council? They are asking you, how do I come up with a trust, isn't it? Because they know that you're doing law, right? So the aspect of having a cetera, and having perhaps a trustor, a trust itself, and perhaps beneficiaries, as it were. And so you need to understand what goes on in the sphere of trust, right? And so how does the law relate to trust? Now, again, I'm going to show you how it does, but then in a nutshell, perhaps off the record, just for the sake of perhaps putting it quite, or should I say for the record, that the doctrine of privity does not apply to the law of trust. That's Very, very, very important. So you have to understand that. That doesn't really apply. And because there are some certain reasons that are there that perhaps are quite demonstrative of this particular fact. One such perhaps is to look at, then perhaps what could be the ramifications if that was going to be the case, right? And so you know that issues of trust are very complicated, isn't it, Council? Because really you are, in a way, leaving this particular, perhaps estate into the hands of a trust, and you can't perhaps really afford to really take it through 100%. Maybe you need to give it a little bit of some allowance, isn't it, Leonard? So just for the sake of having to deal with the beneficiaries and making sure that the beneficiaries perhaps get what belongs to them in terms of benefits, right? And because again, don't forget that it could be certain kinds of relationship, like for example, the ones that are created by nature's burden as a result of creating a trust, that it is based on trust. And so if it is based on trust, so you find that the obligations and the duties that perhaps could be placed on certain parties cannot perhaps make other particular individuals be bound by them. And again, the geometrics do indicate, and they perhaps do spell out the fact that being in that the position, then the beneficiaries would be well protected in terms of the allocation of what could then be required to be provided for, right? So yeah, you talk of that three-tier configuration where you've got a trustor, you've got the trust itself, which is perhaps managed by a board of trustees, and perhaps then you have beneficiaries. And I mean, if at all there's a person who's got a bigger stake here is the beneficiary, isn't it, Council? So even as lawyers, we need to really be wary of the fact that we deal with these aspects of trust in a manner that is quite keen. So perhaps what about if then there are these kind of contracts that come in? So it's a contract that perhaps involves A, B, C party, and maybe you want to secure the trust. How could you then deal with such kind? And so in terms of what about in terms of the enforcement of the rights that could perhaps accrue to the other party? And again, I'm going to speak to that. All I'm trying to do is to give a general synopsis so that you understand how privity of contract has a bearing on what goes in terms of the contract. So other than trust is, I think if you take again on my file, the aspects that you have to deal with collateral contracts, right? Collateral contracts. And yeah, other than collateral contracts, and I thought that maybe from a practical perspective, and I think was it I can't remember very well, our colleague who was in South Africa, who was at one time worried about perhaps jurisdiction, and I must have said, no, what is key is for you to understand the working principles, and must have perhaps put it in light of what would be addressed by other causes of action, right? And because then you may find that, in one way we're saying that you need to be thorough. Now, so how do you then relate to those things that emanate in the domestic relations, right? In the domestic relations. And I think that perhaps that is for your postgraduate studies, but for your level, we'll be calling that for your matrimonial causes, isn't it, Council? Family law, in a nutshell, right? And again, how has perhaps statute law and public policy equally affected and perhaps addresses particular aspects in terms of policy consideration and also in terms of statute provisions is another thing that you need to be wary of. Okay, and these are things that we will try to perhaps address in sufficient detail. Okay, now, how do we start now digressing into perhaps into the deeper water? And I want to request the Learned Council to take us to the case of Dunlop Pneumatic Tire Company versus Selfridge and Company Limited, 1915. Now, at the back of your mind, as someone is going to be furnishing us with the material facts of what could have happened in Dunlop Pneumatic Tire Company Limited versus Selfridge, I want you to know that, and remember that, as Mdada must have said, that the common law doctrine of privity of contract states that a person cannot be bound by or take advantage of a contract to which he is not a party. So that should settle so well in the legal mind, that the common law doctrine of privity of contract states that a person cannot be bound by or take advantage of a contract to which he is not a party. Who's going to read this particular case for us? We want to now break down this particular position of the law. So when we are saying that the rule of privity does mean that, in general, a person who is not privy to a contract, that is, a third party, can neither sue nor be sued on that contract. What do we mean? What do we mean? Yes, in clear terms, from the face of it, yes, it comes out very, very, very clear, because I mean, that is what it is. But I want then to appreciate this particular position from a decided case point of view. And so we want to go into the minds of their lordships to see how they may and how they exemplified it in Dunlop Pneumatic Tire Company. This is Selfridge. Can Council go ahead and read that case? Council, have you found it?
Yeah.
Okay, now if you found it, maybe just read it loud. And I think the other issue is that when somebody is on the platform, when they read, everyone hears, and because by nature's pardon, because of, I think, because of the Bluetooth technology. But if you are in here, then it means that you need to read it much louder. So yes, please, Council, you can go ahead.
Okay. Dunlop Pneumatic Tire Company versus Selfridge, 1915. Face of the case. Dunlop Pneumatic Tire Company, Dunlop manufactured tires. Selfridge Company Limited was a department store. In 1918, Dunlop sold tires to Selfridge. The sale contract included a resale price maintenance clause. Selfridge agreed not to sell Dunlop tires below the recommended price. Dunlop required Selfridge to obtain civil agreements from their customers. Selfridge sold tires to a customer mid-small degree below the recommended price. Issue: Dunlop sought to enforce the resale price maintenance clause against Selfridge. Dunlop claimed Selfridge breached the contract. Lower court rulings. High Court of Justice ruled in favor of Dunlop. Court of Appeal reversed the High Court decision ruling in favor of Selfridge. And judgment was not lauded for the majority. Only a person who is part of a contract can sue on it. A person who is not part to a contract cannot enforce its terms. Key principles. Privity of contract. Only parties to the contract can enforce its terms. Third party rights. A third party cannot enforce contractual terms. Contractual obligations only exist between contracting parties. Significance of the case: establish privity of contract doctrine to trade. Limited contractual rights to parties directly involved. Impacted contractual law influencing subsequent legislation.
Okay, thank you very much, Council Magondo, for that particular case. And I'm hoping that Council Nicolette, you were following Council Magondo when he was making a presentation discourse. So, Council Magondo, if we were to ask, how do you relate the material facts to the position of the law? And so what is the implication of having to deal with privity of contract in this particular context?
Dunlop was conducted to Selfridge, so
Mm-hmm.
he had no any claim
Mm-hmm.
towards, so there was no any credit treatment.
Yeah.
Because according to this case,
Mm-hmm.
I said the contractor was working towards to, not towards the software.
Okay.
So any credit cannot exist between this.
All right.
There was no any contractual agreement.
There wasn't any contractual agreement, and I really hear you. But if you were going to perhaps compare a Dunlop pneumatic tire company is compared to Donoghue versus Stevenson, what would you perhaps be noting as major silent distinctive differences, or perhaps similarities between Dunlop pneumatic tire company and Donoghue versus Stevenson? I think that was a case that you must have dealt with in your tort. Yeah, because there was an issue of privity of contract being spelled out in Donoghue versus Stevenson. So how does it relate to what we are looking at in the case in Castle?
The difference would be in Stevenson versus there was a there was a
Yeah.
It was especially the was it the beer.
The ginger beer.
There was no any contract between there was no any contract between the producer and one who was selling. He was just selling the actual stuff. So there was a pretty bit of contact between Stevenson, between Donald and the company one which was producing the beer.
Okay.
And then when it comes to Dunlop versus Selfridge, there was no any contractual between them.
Okay, thank you very much, Council, for that. Let's perhaps break it down further. Who can break down the case of Dunlop Pneumatic Tire Company? Who was following along? Now, who's got something to add in terms of what Council Magondo has said? Does somebody have a different kind of viewpoint? More especially when Dunlop Pneumatic Tire Company is related to Donoghue versus Stevenson. Yes, Councillor Nicolette, have you noted some distinctive common features or perhaps differences between Donoghue versus Stevenson and Dunlop Pneumatic Tire Company versus Selfridge?
Sir, I don't even hear what Council Magondo said.
Or you were not getting what Council Magondo was saying? All right.
Yes, sir.
Okay. Maybe, or maybe then, have you seen the case of Dunlop Pneumatic Tire Company? Are you reading that particular case in the background? Council Nompumelelo, do you have a sight of the case of Dunlop Pneumatic Tire Company versus Selfridge?
Yes, sir.
Okay. Are you able to read that particular case once more from that particular position so that everyone can hear? Because I think
Okay.
what was happening is that we were not getting, or you didn't get what Council Magondo was reading from here because of a distance.
Okay,
Can
let me read
somebody?
it.
Okay, you can go ahead, Council.
Dunlop Pneumatic Tire Company Limited versus Selfridge Limited, 1915. The facts are as follows. Dunlop was a tire manufacturer who agreed with their dealer to not sell the tires below a recommended retail price, RRP, as part of the agreement. Dunlop also required their dealers to gain the same agreement with their retailers, who in this instance was Selfridge. The agreement held that if tires were sold below the RRP, they'll be required to pay £5 per tire and damages to Dunlop. This was agreed between the dealer and Selfridges, which effectively made Dunlop a third party to that agreement. Sometime after this, Selfridge sold the tires below the agreed price, and Dunlop sued for damages and an injunction to prevent them from continuing this activity. At the initial trial, the decision was given to Dunlop. This was appealed by Selfridge, and the decision was reversed. Dunlop appealed. The issue was Selfridge argued that Dunlop could not enforce the contract as Dunlop was not part of the agreement between the dealer and Selfridges. On this basis, the question for the court was whether Dunlop had the right to access damages without a contractual relationship. Decision or outcome. The court held in a unanimous decision that Dunlop could not claim for damages in the circumstances. The court found that, firstly, only a party to a contract can claim upon it. Secondly, Dunlop had not given any consideration to Selfridge, and therefore there could be no binding contract between the parties. Lastly, Dunlop was not listed as an agent within the contract and could therefore not be included as a valid third party who had rights to claim on the contract. I rest my case.
How are you then relating what you've just read? I think now everyone has understood perhaps the position as it was espoused in Dunlop Pneumatic Tire Company. So how do you then distinguish it from Donoghue versus Stevenson? I think that was now the question. I don't know whether I'm Council Nicolette now, that you would have heard what was coming out from Dunlop Pneumatic Tire Company. That's exactly the same case which Council Magondo had read. How do you distinguish them? Or maybe what we can do is let us give an opportunity to Council Magondo to perhaps tell us his position, and then you can perhaps say what you want to say. So, Council Magondo, what do you make of that?
At first, between the case of Donoghue versus Stevenson, the privilege was there because the company which was producing the beer and they should have owed the dutiful care to the buyer of the beer. So when it comes to this case of Dunlop versus Selfridge, there was no privilege because they were not directly contracted to each other. So there was any privilege between them.
Okay, so I hope, Council, you've got what Council Magondo said. Thank you very much, Council Magondo, for that brilliant contribution. Right, and so is perhaps putting it in clear terms that it was quite expressive of Donoghue versus Stevenson in terms of what was clearly established in the neighbor principle. Now, let's bring it now. Let's scale it further. Let us try to see if we can compare Dunlop Pneumatic Tire Company versus Selfridge and Donoghue versus Stevenson. I think that was now the question for Council Nicolette. Maybe you can now address it, having, I think, laid a very good foundation for the learned council. So, Council Nicolette, then maybe I think now you understand, you can tell us. Okay, maybe before Council Nkomo comes in, I thought maybe let's try to give chance to Council Nicolette, because Council Nicolette was asked this question and she did not get it. Or maybe because Council Nicolette is still processing, let's throw it to Council Nompumelelo.
Okay, sir. So, from my own understanding, the Dunlop case has to do with the breach of a contract term. While it's what's that?
It appears Council Nompumelelo is in a very very noisy place. Or something has come up. I thought that the thought process was perhaps disrupted by the noise in the background. Right? Council.
Okay,
you're back?
saying, okay. With the Stevenson case, it was not as in a breach of a contract as such, it was a tort. So, the Dunlop Pneumatic Tire case was about a breach of contract. Dunlop thought he would appeal against that breach. whilst with the Stevenson case, it was a tort, it was a breach of duty of care instead of a contract term.
Okay, all right, okay, all right. Thank you very much for that. And so, okay, now we can try to cancel Nicolai before we start now looking at these important aspects of breaking it down into the various other exceptions that come with the rule. And so again, it's against this particular background that although privity of contract has been regarded as the fundamental principle of English law, there are a large number of exceptions to the rule which should be understood in terms of what Nganda was talking about. And so what are these perhaps exceptions? And I speak the fact that they can be or they can arise in areas where there's an assignment of contractual rights. And so if it is not in an area where there is an assignment of contractual rights, then perhaps it could be in an area where you are dealing with an agent. So agency, and in agency at this particular level at which you've reached now, because now you are literally, digressing and perhaps traversing into the more detailed landscape of the law itself. You understand that it could be an agent, there could be a principal, and perhaps there could be a third party to that particular effect. So it's this relationship that we need to be looking at in terms of appear on top. Jackson versus Horizon Holiday Limited. Jackson versus Horizon Holiday Limited, 1975. Right, and we will just have to unlock and hear what this particular case does bring out to the fore, right? And because this other, important component of the law of contract that comes in quite exclusively, more especially when it comes to freedom of contract. But then it is in the areas where the exceptions are that it should really come out very clear. And so the examiner will be asking you what is privity of contract and identify the various exceptions to the traditional point of view that has been perhaps been espoused as far as privity of contract is concerned. And so then maybe you need to know 4 of them in detail. Better still, know all of them in detail and be in a position to explain what assignments of contractual rights is, what the agency is as it relates, or perhaps the position of privity when it comes to agency as well as also to land law. Okay, and of course, if it's not land law, then perhaps we'll be talking about the trust, which we've just been talking about here, or indeed collateral contracts. And maybe there could be also those other particular kind of relationships that would emanate in the perhaps in the domestic relations, and maybe that now takes you where to that celebrated case that I must have talked of initially when we were just starting, Beswick versus Beswick. Okay, remember I gave you a case of Beswick versus Beswick, and it was deliberate. I was giving you Beswick versus Beswick because I really wanted you to have perhaps had some form of interaction with these particular cases, and maybe on the assumption that by this time you would have read them in detail, so that even when we come to discuss them in sufficient detail, then we will have a know-how of how the law traverses around and how it deals with these important aspects. So Jackson versus the Horizon Holiday Limited, 1975, is the case that is adding another layer in context to what we are looking at here at this particular juncture. If somebody can find it, then perhaps you are more than welcome. Make sure that you read it. Make sure that you read it. All right. Make sure that you read it. Okay. Sorry? maybe you can just come closer so that you read it from this particular position. We want everyone to have a view of perhaps what been said. So since you're alone, you can perhaps Junior. Okay.
Jackson versus Horizon Holidays, LTD 1975. Facts of the case: Mr. Jackson booked a holiday through Horizon Holidays, a travel company for him and his family, and paid approximately 1,400. He had provided explicit details about the family's accommodation, amenity, and dietary requirements and preference, which had been accepted by Horizon. Shortly before their departure, Horizon informed Jackson that the hotel they had booked was now unavailable, provided an alternative for 1,200, which they proposed to be as just good as the hotel that was originally booked. Upon arrival, the Jacksons found out the new hotel was unsatisfactory. This caused them distress, vexation, discomfort, and inconvenience. They brought action against Horizon for misinterpretation issues, whether damages are recovered by a person making contract to recompense his whole family. It was held the appeal by Horizon was dismissed. Jackson had made a contract with Horizon for a family holiday and was entitled to recover damages not only for a breach of contract by Horizon, but for the discomfort and distress the breach of contract and caused him. Given that he had booked the holiday for him and his family, Mr. Jackson was entitled to also recover damages for distress and discomfort the breach of contract caused to his wife and children. Horizon had known the holiday was for the family, so any breach of contract would be possibility affect the entire family and not just Mr. Jackson, who was part to the contract. Therefore, the figure 1,100 that was awarded in damages on account of Mr. Jackson claimed. I lost it.
Okay, it's been lost. Okay. Okay, that's what I think the. Maybe you can search for it once more. When you find it, you can tell us. And so, yeah, going by what Council has just perhaps given us some forms that you found it, right? I want you to think about this maybe at the back of your mind. Hear this. Yeah, and here, listen and just listen very carefully. Because there is no legal commitment until a contract has been formed, either party may change their mind and they withdraw from negotiations anytime before there is acceptance. Right? And so, with aid of decided case law, discuss how the overall can inform all potential claimants that the offer of a reward has been cancelled. And I'm sure you're very much familiar with that particular question, right? And it's not perhaps news, and you've dealt with this particular question. And maybe I want you to think about what your viewpoint of contract is. Maybe before then you were not perhaps well grounded in the contract, maybe because you were just starting. You didn't have this particular kind of opportunity to unlock the law. Now that you have an understanding of the law, how would you perhaps look at this kind of? I should think if you were going to be given a second chance to find and theory, I think you are both some different right? And I'm already looking at one of the assignments, and once assignment already, that's the way you look at the conclusion. How do you write a conclusion that is just about 3 lines? To a question of such kind of a magnitude, a very, very important contract question. And then you only come up with 3 lines in the conclusion. How? And so where is the ego value from Kumele, right? Because you can't afford to come up with 3 lines, 4 lines, and that's your conclusion. How? And out of all these things that you have discussed, and you only come up with 4 lines in the minimum, the question itself is quite splendid. This is a very powerful question. So even as we're discussing this, I'm asking you these things. You're not asking you to ask yourself, are you doing the right thing? Did you do the right thing? So because there is no legal commitment until a contract has been formed, either party may change the mind and withdraw from negotiations anytime before the peace accepted. With the aid of the side, the case law discuss how the overrule came in form of potential claimants that the offer one as a counsel. And really you go in what you give me is perhaps reproduction and copy and paste, just the concept. You're not really applying yourselves. Okay, yes, so there we have it, cousin. The case once more, and I want to hear your perhaps your comment on that, and then maybe we can perhaps address other aspects which I have itemized deliberately for you, so that I really just make it much easier. We have to avoid having problems of having to deal with assignments that perhaps would be like this. Maybe the second assignments may be better. Okay, yes, because we can read the material.
Okay, therefore, the figure 1,100 that was awarded in damages on account of Mr. Jackson claim by the original trial judge was not considered excessive as it accounted for the distress and discomfort of the whole family. That's the case.
Okay. So that was the case. I think the last disclosed the last part of it. So when we look at Jackson, this is the horizon only the limited 1975. And you are breaking it down. What do you make of it? What legal principle is coming out by this?
I think the Horizon holidays should have notified Mr. Jackson before they were in contractual.
Okay. I hope everyone has gotten the position. Council Nicolette, what is your immediate reaction when you look at Jackson and the horizon holiday? And basically, what do you make of the judgment that was literally delivered? I'm very much particularly interested where perhaps the court makes it clear that the award was designed to cover not only Mr. Jackson's loss, but also the loss suffered by his wife and children. Yes, Councilor Nicolette. Councilor Nkong, there is something on your plate. How do you deal with the crux of the matter? In Jackson, this is the horizon holiday case. I'll just perhaps give it to the owner. And I'm sure now you're seeing that the contract is becoming more advanced on a daily basis.
Because there was a difference in prices.
Yeah, absolutely.
The hotel they booked is different from the hotel they were given.
Yeah.
In terms of prices.
Oh, in terms of pricing, is it? Yes, so there was some form of perhaps difference, attached to that. So what was perhaps the effect of the ramification of having that particular variation?
And because Mr. Jackson can claim that it was unsatisfactory. And Mr. Horizon holidays, it was foreseeable to say that there will be problems with it because Mr. Jackson already notified them that it's coming with this film.
Okay, so when you look at it, and I like the way you did perhaps use the way foreseeability, because I think now you do deeply understand the in French reasoning behind having the concept of foreseeability, right? So yes, that is very key. And so then what about the aspects that perhaps were not when were covered not only by his own distress and disappointment, but perhaps he must have suffered? How will you address
that? In terms of money, he lost some money because the hotel he booked was for 1,400. He was given a hotel for 1,000.
Yeah. Okay. So
he suffered loss.
So he suffered some loss, and it's the loss that perhaps we need to be much interested in. Okay, so those are very important aspects that I wanted us to bring to the fore, right? And because the privilege of contract is quite technical, right? And because it's technical, the most important thing is first of all to understand what it means. So what is basically the common law position? And so the rule of privilege means that in general, a person who is not privy to a contract, that is, the third party can neither sue nor be sued on that contract. Now, you captured this presentation, right? And you sent it into the group, right?
Yes.
Yes, this is very important because it's a summation of what this took place, and this is the working principle. Of course, from the material facts, selling to views, then view sales to sales. Now, in this particular case, you heard of those particular, kind of situation, so where somebody says, "Oh, no, you go and get your money from Mr. Mali." Yeah, Mr. Mali owes me money, right? So you go and see him. But how can you then refer me to Mr. Mali when we can directly perhaps transact, isn't it? Yeah. So this is something similar to that. And so if it is understood in terms of that particular kind of a concept and an approach, then you perhaps know the kind of theory which is there. So you go with this particular diagrammatic representation in your mind, implant it, none, write this off, right? And with it in the example, then you know that when the question comes in terms of privilege, then you will really get it already. Okay. Right. So deliberately, what I thought would be very important was for me to have introduced and have given you the general process, perhaps making you understand what the contract is, and making you know that the rule of privilege means that in general, a person who is not privy to a contract, that is a third party, can neither sue nor be sued on that contract. And giving you this case of Daniel Komati, child hunter versus selfish, right? And so yes, giving you a generous notice on how to say diagrammatic implementation. But this is expressive of the fact that the case of Jackson versus the horizon, the case is what exemplifies this thing that we're talking about, right? Reflective of what? Daniel Komati diagram. Now, as we'll be going into now the various aspects, assignments of contract rights, agents, land law, trust, collateral contracts, and so on and so forth. Then now we'll be going into the specifics. So I do hope and the pray that you would have understood what privilege of contract. You do understand what privilege of contract. So colleagues, Councillor Nicolette, do you understand as to what is meant by privilege of contract? Now? Councillor Nicolette? Sorry? We were asking that, have you? The network is really bad. Okay, the network is really bad for Councillor Nicolette, all right? Okay, so you can yes, advise that the council can check on the pictures which have been sent into the group, right? Right. So we can perhaps just leave it at this, as we've introduced a privilege of contract, and as perhaps it has been well spelled out that privilege of contract does spell out that in general, a person who is not privy to a contract, that is a third party, can neither sue nor be sued on that contract. So we can end at this. I want to call for perhaps a meeting for Friday. Is it okay that we can have a meeting Friday morning? That is if you don't have any class. It's from what time to what time? 8 to 10. Can you have some time for me on Friday? Because I want to now bridge a gap between what we've looked at and the exceptions, so that then we can express them in sufficient detail. Okay, half 10 to half 12. Councilor Magondo is suggesting. Class rep, what do you think? Okay, agreed. Okay, wonderful. So it is agreed. Councilor Nompumelelo has agreed. Councilor Nicolette, you are also agreed? Right, so we will perhaps take it that on the authority of Councilor Magondo and Councilor Nompumelelo, then it is agreed, isn't it? Let us end at this so that I don't overcrowd you with a lot of these particular working principles. One step at a go. If I overdose you, you know what would happen, isn't it? You start memorizing the law. So I will be giving you this prescription bit by bit so that really you internalize and conceptualize the law. So that is what privity of contract is. We've dealt with consideration and we've dealt with other aspects, general working principles, and so on and so forth. And very soon we will be looking at other aspects of contract law, perhaps discharge of contract and so on and so forth. So we are moving at the right pace. And I'm also bearing in mind trying to gauge what is coming out from your assignments so that I can literally also see how perhaps I may add some more dosage, right, to what you need to be given. This is very important. Right. Okay. So that you're given a right prescription of a legal drug, as it were. Okay. All right. Thank you very much, colleagues. Wish to thank you and have yourselves a good day. Okay. So we can end at this. Thank you. Okay. You're welcome. So at least we proceed with the marking and then we upload all the results. Okay. Thank you very much. Yes, you're welcome.